So that's one of those critical things that I thought we needed to do because they hadn't done it. And it's going to really, provide us with metrics and quantify what our clients' physical functional limitations are. Now, some people might think, well, geez, they have all of these symptoms and they've got all this, they have the reports from their doctors and the clinical notes. Why do you need to do this? Because they haven't done it, and we need to hit them with strong supportive evidence. And we talk about this is the only bite of the apple you get this appeal review process.
Hi, I'm Greg Dell. Happy to be joined by Rachel Alters and Cesar Gavidia. And we're going to talk about one of Cesar's resolved cases against the Hartford, in which he recently won a long-term disability appeal, which is often a big challenge considering the magnitude and the frequency of which Hartford denies claims, although we seem to win them often as well because they have to be corrected, Hartford, and provided the right information. And then luckily they do reverse these cases. And this is a perfect example of one in which they did. So in these videos, Cesar, we like to talk about what you did, why the person was denied, and let our subscribers and potential clients and current clients learn about what can I do to make sure my benefits don't get denied. And if they do, what's the road ahead going to be and how am I going to get them reversed? So start with, tell us about your client and why they were denied.
So the insurance company, as you said, is Hartford.
Right.
And it's interesting because I don't think there's probably most people out there, most of the clients or potential clients that are watching these videos and most people in this country every day at some point had the impact of this particular person on their life. They're an Amazon fulfillment associate.
Okay.
Everybody's, ordered something from Amazon.
Okay.
But I think what people probably don't, appreciate about this particular position is how physically laborious and challenging it could be, and how many occupational disabilities and problems develop from being in this position. And in this case, our client had been in this position for a while, and he developed a really bad lumbosacral problem, basically dealing with chronic pain in his extremities, in his lower extremities.
Back problems for people who don't know.
Spinal, back problems, but even beyond back problems, because it got to the point where even his own doctors were so confused by the symptoms he was having. They thought that he might have had MS or a more serious neurological condition. Well, he had to stop working, and he informed Hartford and filed a claim with Hartford, which they actually approved initially. And, he interacted with them and provided them with the necessary, documents and proof of loss that we've talked about so many times in these videos, and claim forms that they'd ask him to complete every couple of months, and forms for his doctors to complete. And it went on and on like this for, almost 2 years. And the reason I say almost 2 years is because we've talked about in our videos how important this period from, 2 years to beyond is, to the claimant, because that's when most of these group policies, and in this particular case with Hartford, the claim goes from being an own occupation disability claim to an any gainful occupation disability claim. That definition and standard of a disability changes. Okay. And oftentimes this is the time when claims fall into scrutiny, they get reviewed, and most often when you see a challenge or termination of the benefits, right? Well, this is exactly what happened to our client. And even before, it wasn't even now that they were even looking at, is he now unable to fulfill the duties of any gainful occupation? They now decided to do an about face and say he's not even disabled from his own occupation anymore. So almost after 2 years of payments to the day, they say, we don't think that you're even disabled from your own occupation anymore. We're terminating your benefits. And that's what they did.
All right. And tell us what they relied upon to do that.
Well, when they started this medical review process, they started compiling all his records. And it's even a question of whether they even got a complete set of all of his records. Yet, a number of doctors, quite a few providers, all right, that were seeing him for his condition. As I was saying, he had an unusual array of symptoms and things that he was having care for. And they did a medical review of all these records. They assigned it to a in-house medical physician consultant. And this consultant, who's probably, has reviewed thousands upon thousands of medical records and claims for Hartford. I don't even know, probably in just just a few months, is now looking through his records and provides an opinion that he doesn't feel the records support any restrictions and limitations any longer, you know, and they did a vocational assessment of their own, a vocational review, which we'll talk about. But basically, this vocational person, because it was so close to that transitionary period, they said, we don't just think you could do your own occupation, but we think you can be a maintenance clerk, a service provider, a service clerk. So they identified these 3, 4, kind of random, unusual occupations and jobs that they could do. And on that basis said, we're not paying you anymore. We're done.
Rachel, how often are you seeing similar denials to this from the Hartford?
Every day. The Hartford, I feel we get a lot of calls where Hartford, it's almost like they have it calendared. They approve a claim, they calendar 24 months. We're going to deny this claim for, saying that they're no longer able to do their, own op, but they can do another occupation. They probably are calendar the vocational review for that, for 18 months after they start paying. And this is it's like clockwork.
The thing about the Amazon employees, and we've represented so many already, and I was just looking the other day about some of the biggest employers in the United States, at least, and Amazon, I think, is in the top 10 right now. This particular position for someone in fulfillment, we talk about job classifications because that's how Hartford and many other disability insurance companies look at it. Where were they classifying the fulfillment job, if you recall? What level of duty was it?
So they classify it in this light physical capacity category. And you have to understand, in terms of what they use, they use this DOT standard for physical functional capabilities and capacities. And they kind of categorize occupations, from sedentary to light to medium to heavy. And look, it doesn't even matter what the specific duties of your occupation are. They just say, oh, your job's sedentary, here's where you fit. This is where you fit. This is where you fit. They don't even go into a real analysis of what your occupational duties are. And if you look at these policies, they don't talk all that much about, they really don't even reference, these physical demand categories, the DOT. What they reference is substantial material duties of your occupation. So we see that, over and over. And it's not just Hartford. It's
Right.
It's every disability insurer that kind of does this same thing. But that's where they categorized his particular occupation.
So knowing what you were up against, which was almost like a typical Hartford denial, is what this one sounds like, where they just do the internal review and then based upon the internal review, they deny.
Mhm.
What did you do in this case in order to get the benefits reversed?
So one thing that was very clear that they didn't do is they do what I call the hands-on examination, because it's just, one, costly for them. It's oftentimes, if they don't get the results they want, what I mean by that is if they don't have a report that says that this person doesn't have functional physical, restrictions and limitations, then they're forced to essentially pay the benefits.
Mhm.
They're now tied and bonded to that functional report that says that they have functional limitations that disables and prevents them from returning to their own occupation or any occupation, and that could be a very damaging piece of evidence for them if they just go and deny it, irrespective of that report and of those opinions. So that's one of those critical things that I thought we needed to do because they hadn't done it, and it's going to really provide us with metrics and quantify what our clients' physical functional limitations are. Now, some people might think, well, geez, they have all of these symptoms and you've got all this, they have the reports from their doctors and the clinical notes. Like, why do you need to do this? Because they haven't done it, and we need to hit them with strong supportive evidence. And we talk about, this is the only bite of the apple you get, this appeal review process.
Mhm.
And if you don't get it, and then suddenly, you submit your appeal and Hartford decides, well, we want to send them to a hands-on exam, a functional capacity exam, or an IME. And you don't have anything to respond with other than, reviewing what they send back to you and saying, oh, we disagree with that. Instead of having your own expert lined up who's going to be able to address some of those findings and say why those are not, valid, or, contest them, and you have some, supportive evidence on your side, then you're going to have a challenging time if they continue denying the claim.
So I know we use these functional capacity exams often to try to provide objective evidence of disability. I know, Rachel, you've used them a lot in your claims, but in this particular case, you were able to obtain the functional capacity exam and go back to the treating doctors and get the additional evidence that you needed in order to get the benefits reversed.
I did that. And we also, what I also did is, because I really didn't like what they had produced with their vocational assessment, these random jobs that really I don't even know where they determined that our client had the qualifications for. So we had our own vocational expert lined up who was able to come in and dispute and challenge those roles that they assigned our client to.
And that was important also because your client went from light duty, arguably medium duty in what they were doing, to now saying they could do sedentary. And did Hartford know the experience, education, and training of this particular person? Or sometimes they send out that activities of daily living questionnaire where they ask the background, but how do they know that the person could even do any of those other jobs without even talking to them?
It's such a superficial review they do in regards to that. It's kind of like this afterthought. Oh, well, we'll do this too. But our doctors already found that, they have no physical restrictions and limitations. So really, they don't even look at that all that much. It's only,
matter.
like I said, an afterthought.
Yeah.
But it's not an afterthought, because the restrictions and limitations, first off, that their doctor's opinions are of our client are invalid, were invalid to begin with. So it's kind of like we learn in law school, the fruit of the poisonous tree, right? Well, the poisonous tree here is this doctor's invalid opinions. And now this vocational assessor is relying on that to say your client's able to go and work in these various roles and occupations.
And have they ever had a vocational assessor disagree with the doctor who says there's no restrictions, limitations, and never? So,
Right.
Well, I think the biggest slap in the face for all the claimants is that they get this letter and they go, okay, you said I was disabled. And then you get another letter and they go, well, we think you could do this other job. But they're not only saying we think you can do this other job, they're basically saying you're better.
right.
And they're like, did I wake up and all of a sudden all my symptoms are gone? Everything's back to normal. I can go back to work? Because 99% of our clients would love to go back to work. They're making significantly less money on disability.
Yeah.
They don't want to be home, yet Hartford thinks like all of a sudden you're better. Well, the doctors didn't clear them. How did your doctor clear them? And now, if they were really going to go get this job and apply, and they had to go back to the doctor from Hartford internally who reviewed the claim and say, I need you to certify that I am not a danger or liability to myself or to this company or anyone else, will you do that? Do you really think that Hartford, we should try this. Do you really think that Hartford doctor is going to sign off and say, yes, this person is fit for duty to return to work?
Not a chance.
I mean, it's easy for them to sit in their, wherever the hell they're sitting and
their
be
ivory
like,
tower of
Yeah. And a lot of these clients are already approved for Social Security disability. So Hartford
right.
forces them to apply. They get approved. Social Security says they can't do any occupation. Hartford goes, that means nothing. Our people say they can. It's just
a typical, like we said in earlier, on another video we did, we were talking about the 2025 trends of long-term disability denials. And one of them that we were all talking about, and you both will probably agree, is that we're seeing more denials, but more denials with less being done. Meaning, whereas you used to get a Hartford denial maybe, and it might have said, okay, you're denied, but we had your file reviewed by 2 or 3 particular doctors. Now it's just, you're denied, and our nurse looked at the file.
Right.
And based upon our nurse's review, despite the fact that you have 2, 3, 4, 5 doctors, our nurse disagrees with the findings. Therefore, you're not disabled.
She's not even qualified to disagree with those findings.
And that's ridiculous. But what Hartford's mentality with that is, we can deny them now. There's no penalties for us whatsoever. Let them appeal. We'll get another opportunity to review it, and maybe we'll do, and they do a better job, usually, on the appeal review. and hopefully that we're going to get someone else who's maybe more qualified. We're able to represent a claimant, get better evidence into them, and now we put Hartford in a position where they really will look unreasonable if they deny the claim. And Caesar, as you know, and Rachel from litigating thousands of these, is that while we may not win every single appeal, we would love to, but there's no guarantee. We're also doing everything possible we can to prove that they acted unreasonably, because that's the standard that we're going to have to prove, is that you're disabled if it goes to lawsuit and you acted unreasonably. And that's where it's really hard for a claimant who tries to do their own appeal to be able to even know. They don't even know what we're talking about when we say acted unreasonably. And so for claimants to try to do that on their own, it's an uphill battle that they could rarely win. So we're always thinking about, let's win the appeal. That's first and foremost. Nobody wants to have a lawsuit. But if we don't win the lawsuit, what does this script, what is this record, what does this body of evidence look like for the federal judge that's ultimately going to make the decision? So congratulations, Caesar, on this win. It's great that it was a win at the change of definition, because unlike if you had won one, which we have a lot, before the change in definition, your client could have a little bit more peace of mind that these benefits are going to continue because they're not going to have to deal with a change of definition. And now I know you'll continue to monitor the claim, do the claimant statement, do the attending physician statement, be the voice with the carrier, and basically just tell the client, treat with the doctor, get us your medical records, review your medical records. We're going to make sure that everything is in line so you don't get yourself in this position again where Hartford can unreasonably deny you. So if you're someone out there with a Hartford long-term disability insurance claim, feel free to reach out to Caesar or Rachel or myself. No matter where you live in the country, we're available to help you, and we'll always provide you with a free initial phone consultation.